Senate Bill 27 is a very simple bill. It just states that self-protection is a good and substantial reason to obtain a wear-carry permit. This bill leaves unchanged all the training and background requirements, fingerprinting, and other legal requirements to wear and carry for wear-carry permit. It brings Maryland in line with 42 other states, plus the District of Columbia, that are all shall issue states. 14 states are actually currently constitutional carry. That just means that law-abiding citizens can carry without even having to go through the permit and background training. This bill doesn't require that. It doesn't change the regime. It just changes the reason to allow self-protection. Currently, our state carry permit requires a, quote, good and substantial reason. We have unfortunately turned over the responsibility on what that definition is to the Maryland State Police, who are, unlike us, unelected officials, and they, through regulation rather than law, define what is the Second Amendment for our Maryland residents. The United States Court of Appeals for the District of Columbia struck down DC's good reason, their similar statute requirement for carry permits in the Wren decision in 2017. DC versus Heller held that citizens have the right to possess operative handguns for self-defense. Heller also made clear that the right belongs to law-abiding citizens. I believe that allowing law-abiding citizens to protect themselves, their families, and their property will increase safety in Maryland. There is little evidence to the contrary. In fact, Pennsylvania issues, as of 2017, had issued 1.27 million permits, and their firearm death rate was 11.7 per 100,000, and that's via the CDC, and that includes all firearm deaths. Virginia, which has 429,000 permits, had a same rate, 11.7 firearm deaths per 100,000. Whereas Maryland, where we issue a fraction of that, somewhere around 12 to 14,000 permits, our rate for firearm deaths was well over 12 per 100,000. And finally, I will just say that this bill conforms with what the founding fathers envisioned when they added the Second Amendment to our U.S. Constitution, which states the right to keep and bear arms, and quote, the important part of that is bear arms shall not be infringed. For these reasons, I urge a favorable vote on Senate Bill 27.
Excellent. Thank you very much, Senator Hough. And we'll move to your primary witness, which is Mr. Penick. Mr. Penick, you're up next. You have 5 minutes. Good to see you.
Thank you, Mr. Chairman, members of the committee. It's a pleasure to be here today. You have my written testimony, and to it, that written testimony I have attached the June 4th, 2020 study conducted by Johns Hopkins University about Baltimore. Let me first echo everything what Senator Hough just said. And in the written testimony, you'll see study after study that indicates that firearms owners who have permits are the most law-abiding people on the face of the planet. That the expansion of carry rights in the last 30 years to include all 42 states and indeed constitutional carry in 14 states has not resulted in any increase in the incidence of violence with guns. So the underlying rationale for Maryland's highly restrictive system is simply not there. And in contrast, people with guns save lives. People with permits have saved lives repeatedly. But more importantly, let's just turn quickly to Baltimore. You now have, and this is documented by the Baltimore study, people carrying firearms because they understand that the police will not protect them. Law-abiding individuals are resorting to carrying the firearms out of sheer necessity because they understand that they cannot rely on the police to protect them from violent crime. That is in itself is a stark testimony to the need to exercise fundamental rights in the city of Baltimore. Heller and McDonald both held that self-defense is a fundamental constitutional right. This is not an abstract right. It's very real in the streets of Baltimore. And yet this state, through its restrictive carry permit system, has effectively disenfranchised those citizens from being able to protect themselves. That's an outrage. So what we have here is you're criminalizing people who are forced to protect themselves and in a situation where they have the very real and legitimate perception that if they do not carry firearms for that purpose, they may be killed on the violent streets of Baltimore. That's absolutely intolerable. You simply can't go on and start and continue to criminalize people who are otherwise law-abiding and make them criminals by virtue of the fact that they're trying to protect themselves and exercise the fundamental right of self-defense that Heller says exists. Now, sooner or later, Maryland's system will fall because it is in direct conflict with the Wren decision and the process of 42 other states. So we can't have the constitutional right meaning one thing in Maryland and another thing in the District of Columbia, especially where the District of Columbia copied Maryland's restrictive system, only to get struck down by the Federal Court of Appeals. So at some point, we will have a Supreme Court decision that will rectify that, and Maryland shall issue, in interest of full disclosure, is actually a party to one such suit now pending in Federal District Court. The rationale for that suit is to present this issue to the Supreme Court. There is already one case before the Supreme Court now, and out of the state of New York, that presents this conflict to the Supreme Court. So it was nearly resolved last year in a case called Correll, but the court and the New York State Rifle and Pistol Associations refused to reach the issue what the standard of review is. If this court reaches the issue of the standard of review in any Second Amendment case, and I don't care if it's the Kerry case or some other case, then you will find that the court will probably, more likely than not, say it's Kerry restrictions like other restrictions are governed by text, history, and tradition. And there is simply no way that standard would allow Maryland's statute to survive. But in the meantime, I would urge you to act to protect otherwise law-abiding individuals in Baltimore who are forced to carry for their own self-protection. That the state allows this to continue and criminalize those who do so means that they're subjected to the lottery system of the state attorney's office, who by and large doesn't prosecute unless they feel like it. Simple illegal carry. But no one knows ahead of time. So it is a crapshoot, if you will, about whether or not you're going to be charged, and if you're charged, whether or not you're going to be convicted. Those statistics are set forth in the Hopkins study. I'm not making this up. So you have a state attorney's office who isn't enforcing the law that you wrote, and is not, to the extent it does so on a pretty much arbitrary basis.
Time.
So
Right.
with that, I would conclude my remarks.
Thank you, Mr. Penick. And with that, we'll move on to Mr. Joslin. You are up next.
Good afternoon, Mr. Chairman, members of the committee. John Joslin speaking for 2A Maryland. Over the years, various bills have been proposed to define the nebulous term good and substantial. All have failed. I would note that there are 22 distinct licenses listed on the DLLR website. All of these licenses have very specific requirements and credentials you must have in order to get a license. This is very clear, it's easy to understand. However, when it comes to a carry permit, no such standards exist. We continue to struggle with the definition of a term that is yet to be defined. The Maryland State Police have tried to determine this. They have used various interpretations over the 5 decades this permit law has been in place. And as it varies, as they try to come up with what the intent was, we end up with a bit of a dichotomy as to what is and what isn't a good and substantial reason. We believe that the people of Maryland deserve better. We believe the Maryland State Police deserve better. They are not a legislative body. They should not have to make this decision. We believe that the only way that the law can apply to all is that when critical terms that have not been defined are finally defined. We believe that this is the time for the Maryland General Assembly to step up and place its faith in the people as the people of Maryland have placed their faith in them. We ask for a favorable report.
So thank you, Mr. Joslin. Next, we'll move on to Mr. Boston. You are up next.
Good afternoon, Mr. Chairman, members of the committee. I'm Frank Boston III. I'm here on behalf of the NRA, and we support this bill. And thanks Senator Hough for putting it in. Before I read my testimony, because of time, I do want to make this point. If we had laws like this passed, I would not have lost a friend on Saturday. I had a friend, 58 years old, from Pikesville, who was out servicing ATMs at 11 a.m. in Baltimore City, comes out of the actual store, and he got shot, killed, and pronounced dead on the scene. Maybe had he had the right to carry firearms, maybe he would still be allowed today because he could protect himself. Senate Bill 27 would improve Maryland's permit regime by curtailing the state police's current unfettered discretion over issuance. The legislation would alter the public safety code to make clear that personal protection and self-defense are good and substantial reasons to carry a handgun. This change would create a fairer and more predictable permitting process and would ensure that more law-abiding Marylanders could exercise the right to carry in defense of themselves, their families, and their communities. Maryland is an outlier on the right to carry. At present, 40 states and the District of Columbia have shall issue laws requiring that carry permits be issued to qualified applicants. Moreover, 16 states allow law-abiding residents to exercise the right to carry without a permit. As of June 30th, 2020, Maryland only had 27,760 active handgun wear and carry permits. Among states that are that have a permitting scheme, Maryland ranked 5th lowest in the number of permits granted as a percentage of the adult population. The Second Amendment protects the right to bear a firearm for self-defense outside of their home. In District of Columbia versus Heller, 2008, the Supreme Court made clear that the inherent right of self-defense has been central to the Second Amendment right. With that, Mr. Chairman, members of the committee, we ask for a favorable report on this bill. It is time.
All right, thank you very much, Mr. Boston. Looking around the committee for questions, and I just have one for either Senator Carter has a question.
Thank you, Mr. Chair. My question is short for Mr. Boston. I just was curious about the 58-year-old. I read about that in the paper, and what was so I trust he wasn't a business owner, although he was servicing the ATMs. So he wasn't, what was his role? What was his job? And why was he ineligible for a wear and carry permit?
Mr. Boston, you're still muted. Let me go ahead and hear you.
Can you hear me now?
We can.
Yeah, I don't know whether he was or wasn't eligible. I don't know that. I'll never get the chance to talk to him. Maybe I'll find out from family members. But I do know this is the perfect, type of situation. It's the perfect, sadly, a perfect example of, this is a businessman going to service an ATM machine. Had he been armed, maybe he could have protected himself. I don't know the facts of the intrinsic facts because it just happened on Saturday. But I do know he has kids, he's a family man, and he's not coming home to his family. This is just a good example of many people who are business people or just regular citizens who have a right and need to protect themselves.
Thank you.
Yeah.
Thank you, Senator Carter. Thank you, Mr. Boston. My new cousin, my niece married into your family, so we're family members now. But
yes, we are family.
There you go. Well, good to see you.
Good to see you.
Senator Bailey, you're up next.
Thank you very much, Mr. Chairman. Mr. Penick, I think this question might be more appropriate for you, but I was going to give you a couple scenarios. If you were a businessman in Maryland and you were going to transport money from your business to the bank, would this qualify as a good and substantial reason for you to get a handgun permit to protect your money?
The way the state police are currently interpreting the statute is that they will accord a permit to a business owner only for the purposes of being the owner of the business. It's an unrestricted permit. His employees are restricted to the extent that they qualify, are restricted to the course of employment. So you would have to jump through all the hoops. And bear in mind, it takes over like 90 days to get a permit in Maryland. So it's hardly something one can get rapidly.
So if you were the owner of the business, it would be a good and substantial reason to be able to protect your money?
Yes.
Yes, okay. But if you were a military veteran, somebody that was trained, somebody that was experienced, and you put an application in simply to be able to carry a handgun that you wanted to just to be able to protect your family, being that you were home, you were here with your family, and you wanted to make sure that if anything happened, you'd be able to protect them. Would that be a good and substantial reason currently for you to get a handgun?
Most certainly not. The state police requires special circumstances for self-protection above and beyond the standard harm associated with being a citizen in Maryland. So you have to show actual proof of threats, documented proof of threats, and it has to be more than one. So the criminals kind of get freebies before you can actually get a permit in Maryland.
Thank you.
All right, thank you, Senator Bailey. Further questions from the committee? I just had one for either Mr. Penick or Senator Hough. It was that, so in the, Senator Hough, in your opening remarks, or I think in Mr. Penick, you may have mentioned this, that there may be another case moving forward. So in the Fourth Circuit, you had the Gallagher case back in 2013, Fourth Circuit decision, Supreme Court denied cert. And then you had the Palazzi decision, also Maryland case, denied cert. I think, and then obviously you have the Wren and Heller, obviously DC. So you've got a circuit court split on this issue, even regionally. But did one of you mention that there's another case either through the Fourth Circuit or second working its way up
yes,
to the Supreme Court?
Mr. Chairman, there is a case pending for cert right now, and it's the citation is actually in my written testimony in the docket number. So that comes out of the state of New York. It has a similar good cause requirement that's indistinguishable from Maryland's. So that's currently before the Supreme Court now. There's a case filed that MSI is a party to in federal district court, which is designed to work its way up quickly through the lower courts and to present the same issue with respect to Maryland to the Supreme Court. So one of these days, perhaps soon, with the change in membership of the Supreme Court, we hope the court will grant cert in one of these cases.
That was my second part of the question. Is a little bit of conjecture there, but just what is the composition of the Supreme Court, the new composition of the Supreme Court? What do you think that portends? But I think I got where you're going on that. Okay, great, interesting. We shall see. We shall not issue yet, but anyway, stupid joke. All right, with that, that'll conclude the hearing. Seeing no further questions for Senate Bill 27. Thank you, Senator Hough.